Murray v. United States, Supreme Court, 1988. Justice Scalia delivered the opinion of the court. In Segura v. United States in 1984, we held that a police officer's illegal entry upon private premises did not require suppression of evidence subsequently discovered at those premises when executing a search warrant obtained on the basis of information wholly unconnected with the initial entry. In these consolidated cases, we are faced with the question of whether, again assuming evidence obtained pursuant to an independently obtained search warrant, the portion of such evidence that had been observed in plain view at the time of a prior illegal entry must be suppressed. 1. Both cases arise out of the conviction of petitioner Michael F. Murray, petitioner James D. Carter, and others for conspiracy to possess and distribute illegal drugs. Insofar as relevant for our purposes, the facts are as follows. Based on information received from informants, federal law enforcement agents had been surveilling petitioner Murray and several of his co-conspirators. At about 1:45 p.m. on April 6, 1983, they observed Murray drive a truck and Carter drive a green camper into a warehouse in South Boston. When the petitioners drove the vehicles out about 20 minutes later, the surveilling agents saw within the warehouse two individuals in a tractor-trailer rig bearing a long, dark container. Murray and Carter later turned over the truck and camper to the other drivers, who were in turn followed and ultimately arrested, and the vehicles lawfully seized. Both vehicles were found to contain marijuana. After receiving this information, several of the agents converged on the South Boston warehouse and forced entry. They found the warehouse unoccupied, but observed in plain view numerous burlap-wrapped bales that were later found to contain marijuana. They left without disturbing the bales, kept the warehouse under surveillance, and did not re-enter it until they had a search warrant. In applying for the warrant, the agents did not mention the prior entry and did not rely on any observations made during that entry. When the warrant was issued at 10:40 p.m., approximately 8 hours after the initial entry, the agents immediately re-entered the warehouse and seized 270 bales of marijuana and notebooks listing customers for whom the bales were destined. Before trial, petitioners moved to suppress the evidence found in the warehouse. The district court denied the motion, rejecting petitioners' arguments that the warrant was invalid because the agents did not inform the magistrate about their prior warrantless entry and that the warrant was tainted by that entry. The First Circuit affirmed, assuming for purposes of its decision, that the first entry into the warehouse was unlawful. 2. The exclusionary rule prohibits introduction into evidence of tangible materials seized during an unlawful search and of testimony concerning knowledge acquired during an unlawful search. Beyond that, the exclusionary rule also prohibits the introduction of derivative evidence, both tangible and testimonial, that is the product of the primary evidence, or that is otherwise acquired as an indirect result of the unlawful search, up to the point at which the connection with the unlawful search becomes so attenuated as to dissipate the taint. Almost simultaneously with our development of the exclusionary rule in the first quarter of the century, we also announced what has come to be known as the independent source doctrine. That doctrine, which has been applied to evidence acquired not only through Fourth Amendment violations, but also through Fifth and Sixth Amendment violations, has recently been described as follows. The interest of society in deterring unlawful police conduct and the public interest in having juries receiving all probative evidence of a crime are properly balanced by putting the police in the same, not a worse, position that they would have been if no police error or misconduct had occurred. When the challenged evidence has an independent source, exclusion of such evidence would put the police in a worse position than they would have been absent any error or violation. The dispute here is over the scope of this doctrine. Petitioners contend that it applies only to evidence obtained for the first time during an independent lawful search. The government argues that it applies also to evidence initially discovered during or as a consequence of an unlawful search, but later obtained independently from activities untainted by the initial illegality. We think the government's view has better support in both precedent and policy. Our cases have used the concept of independent source in a more general and a more specific sense. The more general sense identifies all evidence acquired in a fashion untainted by the illegal evidence-gathering activity. Thus, where an unlawful entry has given investigators knowledge of facts X and Y, but facts Z has been learned by other means, fact Z can be said to be admissible because derived from an independent source. This is how we use the term in Segura v. United States from 1984. The original use of this term, however, and its more important use for purposes of these cases, was more specific. It was originally applied in the exclusionary rule context by Justice Holmes with reference to that particular category of evidence acquired by an untainted search which is identical to the evidence unlawfully acquired. That is, in the example just given, to knowledge of facts X and Y derived from an independent source. The essence of a provision permitting the acquisition of evidence in a certain way is that not merely evidence so acquired shall not be used before the court, but that it shall be used at all. Of course, this does not mean that the facts thus obtained become sacred and inaccessible. If knowledge of them is gained from an independent source, they may be proved like any others. Petitioners' asserted policy basis for excluding evidence which is initially discovered during an illegal search but is subsequently acquired through an independent and lawful source is that a contrary rule will remove all deterrence to and indeed positively encourage unlawful police searches. As petitioners see the incentives, law enforcement officers will routinely enter without a warrant to make sure that what they expect to be on the premises is in fact there. If it is not, they will have spared themselves the time and trouble of getting a warrant. If it is, they can get a warrant and use the evidence despite the unlawful entry. We see the incentives differently. An officer with probable cause sufficient to obtain a search warrant would be foolish to enter the premises first in an unlawful manner. By doing so, he would risk suppression of all evidence on the premises, both seen and unseen, since his actions would add to the normal burden of convincing a magistrate that there is probable cause, the much more onerous burden of convincing a trial court that no information gained from the illegal entry affected either the law enforcement officer's decision to seek a warrant or the magistrate's decision to grant it. Nor would the officer, without sufficient probable cause to obtain a search warrant, have any added incentive to conduct an unlawful entry, since whatever he finds cannot be used to establish probable cause before a magistrate. 3. To apply what we have said to the present cases, knowledge that the marijuana was in the warehouse was assuredly acquired at the time of the unlawful entry, but it was also acquired at the time of entry pursuant to the warrant. And if that later acquisition was not the result of the earlier entry, there is no reason why the independent source doctrine should not apply. Invoking the exclusionary rule would put the police and society not in the same position they would have occupied if no violation occurred, but in a worse one. The ultimate question, therefore, is whether the search pursuant to a warrant was in fact a genuinely independent source of the information and tangible evidence at issue here. This would not have been the case if the agent's decision to seek the warrant was prompted by what they had seen during the initial entry, or if the information obtained during that entry was presented to the magistrate and affected his decision to issue the warrant. On this point, the Court of Appeals said the following: "We can be absolutely certain that the warrantless entry in no way contributed in the slightest either to the issuance of a warrant or to the discovery of the evidence during the lawful search that occurred pursuant to the warrant." Although these statements can be read to provide emphatic support for the government's position, it is the function of the district court rather than the Court of Appeals to determine the facts, and we do not think the Court of Appeals' conclusions are supported by adequate findings. The district court found that the agents did not reveal their warrantless entry to the magistrate and that they did not include in their application for a warrant any recitation of their observations in the warehouse. It did not, however, explicitly find that the agents would have sought a warrant if they had not earlier entered the warehouse. The government concedes this in its brief. To be sure, the district court did determine that the purpose of the warrantless entry was in part to guard against the destruction of possibly critical evidence, and one could perhaps infer from this that the agents who made the entry already planned to obtain that critical evidence through a warrant-authorized search. That interference is not, however, clear enough to justify the conclusion that the district court's finding amounted to a determination of an independent source. Accordingly, we vacate the judgment and remand the cases to the Court of Appeals with instructions that it remand to the district court for determination whether the warrant-authorized search of the warehouse was an independent source of the challenged evidence in the sense we have described.